My name is Siskinds, and my practice focuses on Canadian and US business, technology, and privacy law. This video is about privacy impact assessments, which are assessments that may become mandatory for your business in the coming weeks. What is a privacy impact assessment? Privacy impact assessments, or PIAs, are risk assessments that are useful for identifying and managing privacy risks. I want to stress the proactive nature of PIAs. Your business should do a PIA before implementing a system or service that involves the processing of personal data. Think of PIAs as an early warning system. If you find some red flags, you can resolve the red flags before implementing the system or service. You may be thinking, PIAs are another big paperwork hassle, or you could also be thinking that it would take forever for your business to do a PIA for every system or service involving personal data. The good news is that's not quite accurate. PIAs will vary depending on their nature, scope, and content. Also, by conducting PIAs, your business will become more selective and careful in how it processes personal data. Your business will become more accountable, and PIAs will reduce the risk of privacy issues that hurt your business's reputation. For the most part, PIAs will include generally 5 topics. First, a description of the proposed system or service. Second, an identification of the personal data being collected, how you're collecting it, from whom and for what purpose, how will the personal data be used, disclosed, and retained, and how will your business protect that personal data. The third topic is whether the system or service complies with applicable privacy law. Fourth is whether there are any privacy risks and an identification of the severity of those risks. And lastly, a clear plan of action forward to avoid those risks. Importantly, after you finish the PIA, your task is not done. You should continuously review and update your PIAs as the system or service changes. For next steps, your business should develop an internal PIA procedure for staff to follow, along with perhaps a PIA template they can use to ensure that your business is in compliance with privacy law. The next question is, why are PIAs important for your business? As of right now, PIAs in many jurisdictions are generally a best practice. However, privacy laws throughout Canada and the United States are rapidly changing. Some jurisdictions already require PIAs, and others are expected to follow suit. For example, starting on September 22nd of 2023, Quebec law will require PIAs in certain circumstances, including when businesses send personal data outside of Quebec. If your business is exporting personal data from Quebec to Ontario, your business now needs to perform a PIA. Crucially, Quebec will also require businesses to enter into data protection agreements that take into account the results of the PIA. Learn more about data protection agreements in my other video. What was once a best practice is now becoming a legally mandated practice. This new Quebec law is quite telling for future Canadian privacy law developments. Don't expect it to be the last. If you ever need guidance on this issue, or if you have any technology, business, privacy, or cybersecurity questions, please don't hesitate to reach out. We're always happy to help.